Hello everyone, and good day to my lecturer, Miss Asmita, and my fellow classmates. Today, I will be presenting the topic number 28, which discusses vessel unseaworthiness and the legal liability of a carrier when unseaworthiness combines with another cause, such as crew negligence, heavy weather, and to damage cargo. So, my name is Agustin Philip. I'm from DSM 3. Before discussing the legal principles, it is important to understand what unseaworthy means. A vessel is considered seaworthy when it is reasonably fit for the intended voyage. This means the ship must have a sound structure, properly functioning machinery, suitable cargo holds, sufficient equipment, adequate fuel, and competent crew. If any of these incited requirements are missing at the beginning of the voyage, the vessel is regarded as unseaworthy. The main legal issue is whether the carrier remains liable when cargo damage is caused by more than one factor. For example, a ship may have a defective hatch cover before departure. During the voyage, the vessel encounters heavy weather, allowing seawater to enter through the defective hatch and damage to cargo. In this situation, both the defective hatch and the heavy weather contribute to the cargo loss. Under the common law, the carrier cannot avoid liability simply because another event also contributed to the damage. If the initial unseaworthy condition is one of the effective causes of the loss, the carrier will still be held responsible. In other words, unseaworthiness does not have to be the sole of exclusive cause. It is sufficient that it materially contributes to the damage suffered by the cargo owner. This legal principle ensures that ship owners fulfill their duty to provide a seaworthy vessel before the voyage begins. It also protects cargo owners by preventing carriers from relying on external events to escape liability when the vessel was already unfit at the commencement of the voyage. The case that illustrates this principle is Machine Footwear Ltd. v. Canadian Government Merchant Marine, which is from 1959. In this case, the vessel was found to be unseaworthy before the voyage started. A fire later destroyed the cargo, and the court found that the initial unseaworthy condition contributed to the loss. Even though other factors were involved, the carrier remained liable because the unseaworthiness was an effective cause of the damage. The carrier could not rely on contractual exceptions to avoid responsibility. So, a simple example is a refrigerated vessel transporting frozen seafood. Before departure, the refrigeration system is already defective, making the vessel unseaworthy. And during the voyage, the crew also fails to monitor the cargo temperature properly. As a result, the seafood spoils and made the defective refrigeration system existed before the voyage and contributed to the damage. The carrier remains liable, even though crew negligence also play a role. In conclusion, a carrier has a legal duty to provide a seaworthy vessel at the beginning of the voyage. If an unseaworthy condition combines with another cause, such as crew negligence, heavy weather, and to damage cargo, the carrier may still be held liable, and the important point is that unseaworthiness only needs to be one effective cause of the loss and does not have to be the only cause, and the missing footwear case clearly demonstrated this important principle under common law. That's all for me. Thank you for your attention, and hope you guys healthy every day. That's all for me.